Sure. Let's admit.
Oh, no, I have to.
Oh, I think I can do it.
Oh, I think now you're doing it. Yeah.
Hi, folks. Thanks for joining us. We are just taking one more minute to let people log in, and then we will get started. As you may have seen, our colleague Natasha just posted just a little some CLE housekeeping things to keep in mind. Um, and in that beginning part, there's also the link to the feedback survey. If you are wanting CLE credits, please make sure to fill that out so that we can make sure to get your information entered in for this CLE. So Sarah, should we start? We're at 12:04.
Yeah, let's go ahead and get started. Well, welcome to our Lunch Matters CLE, responding to abusive litigation in sexual assault cases. If anyone's not familiar with our program, just quickly, we are a civil legal aid firm of 6 attorneys, and we work with survivors of all genders and ages statewide. We represent them in their emergency legal needs in multiple areas of law because sexual assault impacts so many aspects of a survivor's life. Our model is holistic and trauma-informed, and we strive to center our advocacy in race and gender equity principles. Quickly, we want to acknowledge and recognize our partner, one of our partners in support of the CLE series. We had received an equity grant to partner with the South Asian Bar Association of Washington. And we're really looking forward to SABA members volunteering and providing pro bono legal assistance to the survivors we serve. So thank you. You can see on the slide, here, did I skip ahead, Reedy? Sorry. You can see the different areas of law that we practice on the slide there. As I mentioned, we work with people of all gender identities, all ages, both adults and children. I said that we were holistic and trauma informed. Holistic means that we try and address all the legal issues a survivor faces as results of a sexual assault. There was a 2015 study that found an average indigent person had 7 to 8 legal needs, but when that person was experiencing domestic or sexual violence, those legal needs skyrocketed to 18 to 19. In supporting survivors, we provide litigation and assistance at different levels, including taking cases for direct representation, advocacy, so at the legislative level, advocating for policy reform. We do try to educate different communities, lawyers, the bar, organizations doing trainings much like this. And then we also connect survivors to other resources that can provide other assistance that we can't.
Thank you for that, Sarah. And because abusive litigation, we see this a lot also with stalking and tech abuse related cases. We just also wanted to identify one of our special initiatives is our tech enabled coercive control initiative that's now housed as the Sexual Violence Law Center. You may have known it as the tech working group previously that many advocates within the community had started. And it's just recognizing that our digital technology that is both very much a part of our daily life can also become a platform of abuse, and which we've identified as tech-enabled coercive control. And so through the initiative, we are looking to address and assist survivors who are experiencing tech-based abuse, and hopefully work with institutions and systems on better responding to these types of cases. And also acknowledging, in the past we would do a poll, but just acknowledging that there are survivors among us. We know the statistics: 1 in 3 women will experience sexual violence in their lifetime. 1 in 6 men will experience sexual violence in their lifetime, and 1 in 2 non-binary individuals or not gender non-conforming individuals will experience sexual violence in their lifetime. And that vulnerability increases even more drastically. I mean, it's already considered a pandemic, as sexual violence is considered a pandemic and a public health issue. And that vulnerability increases even more based on if somebody has a disability, based on their race, based on other identifying factors. So just recognizing there are survivors among us, and to be thoughtful and respectful with the questions that we might ask or comments that we might be making during this training. And also, please do take care of yourself, because when talking about abuse and abusive conduct, for some of you, it can be triggering. So please do take care of yourself. And then a lot of abusive litigation has really, the language around it, the trainings around it have really focused on domestic violence. One reason why we wanted to have a webinar on this is the fact is that sexual violence and stalking, the perpetrators in these cases also can engage in intensive abusive litigation, and sometimes it just has a different form. It's no longer necessarily focused on the family law case, but it's through other ways, like defamation cases or personal injury lawsuits, and that can be really exhausting as well. And so we just wanted to kind of expand the conversation beyond abusive litigation in DV to other gender-based violence cases. So we just have a quick poll here. If in the chat, if you could just say, have you worked with a client, or maybe you've experienced abusive litigation? No for N, Y for yes, and S for not sure, which is okay, because you may also not be familiar with the term abusive litigation yet.
A lot of Ys I'm seeing.
Okay, Sarah, do you see the chat? Has it slowed down?
They're still coming. Primarily Ys, some not sures. I think I've only seen one no.
It's one of those terms that I don't think you hear necessarily every day, but once you hear it, it kind of captures probably experiences that you've had in court, certain cases that you've had. Okay, how's it looking, Sarah?
Yeah, I think it's slowing down. Okay.
So mostly Ys still?
Yeah.
Not sure's, and then 1 or 2 no's. Yeah. Okay.
Yeah, most people have definitely encountered it, it looks like. Oh, sorry. So what is abusive litigation? So this is from the Washington Domestic Violence Bench Guide. The term abusive litigation includes the misuse of court proceedings by abusers to control, harass, intimidate, coerce, and/or impoverish survivors. This is done typically without merit. Their conduct or claims are baseless, and it's a misuse of the judicial system. And abusers engage in this tactic for several reasons. It's a way to reestablish and retain control even after a relationship has ended. It's a way to punish the survivor for seeking their legal remedy and exercising their rights. It's a legal form of abuse. Often it's allowed to happen unchecked and without consequence. That's because survivors are often unrepresented, and oftentimes their abusers can afford counsel. Even if the survivor has counsel, attorneys often withdraw after the survivor can no longer pay fees. Fees are exacerbated because of the volume of work that abusers and their counsel and advocates create. And aside from fees, even just a survivor's attorney can get worn down by the amount of litigation. Again, just talking about the volume of work that can be created. Courts don't always recognize that this is happening, or they don't see really the full extent of the tactics being used. And if abusers lose in one forum or are unsuccessful, they will just try another. The legal system provides, multiple avenues for this kind of abuse and these tactics.
Thank you for that, Sarah. And the DV Bench Guide, I think this has been sort of the language that we've used for a while to describe abusive litigation. The appendix, Natasha just, I think, posted it. That was actually developed by Legal Voice and David Ward. So any of you who've been to David Ward's training, past training on abusive litigation, some of this will sound very familiar to you. So we actually wanted to share an example of what abusive litigation can look like. So let me play this. And I think this is a very classic example of abusive litigation.
Yes, Your Honor. Your Honor, every one of these letters is addressed to Santa Claus. The post office has delivered them. Therefore, the Post Office Department, a branch of the federal government, recognizes this man, Kris Kringle, to be the one and only Santa Claus.
Since the United States government declares this man to be Santa Claus, this court will not dispute it. Case dismissed.
So, how many of you, when you watched this as a kid, thought about this scene as abusive litigation? This is actually a very beloved, I still love this scene from Miracle on 34th Street, the 1947 version, I think. And the way the story is and the way this court proceeding works, it's, a feisty young lawyer who really is sticking it to the man and representing Santa Claus and keeping Kris, and basically saves Kris Kringle with his creative advocacy. But if you think about this, just this scene, if you just think about this scene, not the full story, this is actually what abusive litigation looks like. It's a last minute filing. It's voluminous. I mean, they literally pile the bench with letters. There's no notice to the other side. No copies were provided to the other side. It's essentially paper abuse. It's overwhelming the court and the other party. So it's a little bit of a humorous take, but in case you hadn't experienced it, I thought we could show you an example of what abusive litigation could look like in court. And so what are some other abusive tactics that are part of abusive litigation? Sarah, do you want to take this?
Yeah, so this may be a little more familiar or more like what you will experience than what we saw. But so for example, repeatedly filing frivolous motions, frivolous actions. So that could be appeals, motions for revision, motions for reconsideration, trying to re-litigate issues that have already been decided, bringing parallel litigation in different courts because they're not getting maybe the results that they want in the other courts, abusing the discovery process. This oftentimes will look like seeking things that are far outside the scope of what they would be entitled to or what would be relevant and material to the case. Prolonging the case through repeated continuances. And often this can turn into abusers firing and hiring new lawyers with the understanding that this is the only way that they're going to get another continuance. Deliberately refusing to comply with the court orders and filing retaliatory lawsuits, threatening lawsuits, defamation claims, liability claims. And these threats can be made to the survivor or even to supporters of the survivor, and then engaging other systems in the case. So making false reports to law enforcement, to CPS, making claims that the survivor is an unfit parent, that they are a danger to themselves or others, or if you're working with an undocumented survivor, threatening immigration consequences and deportation against the survivor. So again, I think one of the big red flags and something that is easy to sort of recognize is what we saw in the video, and that is when there is just, you're buried in paperwork, when the pleadings and the motions just keep coming. That's an indicator that you have someone engaging in abusive litigation.
Do you want to take this too, Sarah?
Sure. So what does this do to your client? Well, obviously it exhausts them, but it also really impacts their experience with the legal system. It creates a loss of trust in the legal system, which they have gone to at a minimum to pursue their rights, and more than that, often to seek protection. It forces, the legal system already forces survivors to have contact with their abusers, and with these tactics, particularly the continuances, that contact is increased. It is a form of coercion for the survivor to make concessions in order to just end the abuse or have the abuse end. It has financial impacts, again, especially for, even if they're not represented, but if a survivor is represented, creating that work for the survivor's attorney creates costs. It has emotional and psychological impacts. We kind of covered that in terms of really making the court experience one of fear rather than one of exercising rights and pursuing justice. And then it can really cause isolation and loss of social support. Those who really want to support a survivor may be reluctant and even fearful to do so because of the conduct of the abuser and even direct threats of the abuser to those support systems. Quickly, we want to share a couple of just quotes from survivors describing their experience in the court. One is a survivor interviewed by Arizona Coalition Against DV's Battered Mothers Testimony Project. And she said, "He never stops harassing me. The courts are his legal playground. He uses the courts to inflict suffering. He constantly, and I do mean constantly, has me in court. His lawyer helps him to wear us out. The end is never coming. It never ends." And then one other survivor who was interviewed by Legal Voice, Violence Against Women Work Group, about going to court. "I literally get sick. I shake, I cry. I hate going to court. They're not going to stop, and the courts bless them. We are living out a life sentence of trauma and terror sanctioned by family court. So this is real impact and real harm that survivors are experiencing.
The other aspect of abusive litigation is that often the abuser is not doing this alone. I just want to note that the focus in abusers themselves, the focus of this presentation is the abusers themselves, but our legal profession also perpetuates harmful myths about domestic violence and sexual assault. And this is an example of a CLE from a few years ago, where a lot of this harmful victim blaming language was used throughout trainings, and we continue to see these in trainings that then almost justify the abusive litigation tactic because of how victim credibility is questioned from the very beginning, because of making it seem like when you're bringing a case based on sexual assault, based on stalking, based on domestic violence, that somehow false reports are higher in DV, sexual assault, stalking cases, even though we actually know that's not true. So at our own profession also can perpetuate this, and that's something to also be thoughtful about when you're dealing with a abusive litigant. Sometimes you also really need to focus on the attorney as well, based on the kind of conduct that they're engaging in. The other aspect is the abuser brings in other professionals like mental health experts who also perpetuate problematic ideas and false myths. And like I think about parental alienation as an example of something that's been debunked, but continues to still be used in the family law process. And that language is still used, even though it's problematic. And now it's actually something that courts should not be engaging in that sort of analysis. The other aspect of abusive litigation is really paying attention to language. It's important to know that how language is used by the abuser, by the abusive litigant, that is often victim blaming, that often implies consent, often makes it seem like the survivor was okay with everything and is in agreement, and then often is very minimizing of the harm that they've caused the survivor. And to be very thoughtful that we don't unintentionally end up repeating and parroting the language, victim blaming language, the minimizing language that often abusive litigants will end up using when we're responding, when we're litigating against a vexatious, against an abusive litigant. And I think Natasha also posted last month's CLE, we specifically focused on use of consensual language in sexual assault cases. The focus is more on litigation itself. And, but I think a lot of those principles apply here as well. So that's just like a little bit of the background, this kind of just to make sure we all have some, are starting from the same sort of foundation around what abusive litigation looks like. So we wanted to talk about responsive strategies, and we're hoping to really set some time aside at the end. So those of you who are on here can also share, because this is still an area where creative strategies, like we need to be talking to each other and learning how to respond to this. So please do share, or as we're going along, if you come up with other strategies that you found really helpful, please put it in the chat. Because multiple tools do exist. Do you want to take this one, Sarah?
Sure. So, you know, obviously the court has the most power, I guess, to address this issue. So first of all, the court should admonish parties who engage in abusive litigation. And it's important that after a party has been admonished, if that continues, that there is some sort of a consequence. It is possible for courts to keep what we are calling an abusive litigant list. This is actually something that is done, I know in California, and they call it something else, but you know, the clerks, the courts, the staff at the courts, they're the ones who know who come to court, who is filing actions. They know who the, for lack of a better term, frequent flyers are. And so the court could keep a list so that it's known to the bar at that court who these people are. And if you have, depending on your, you know, obviously relationship with the court, with your judiciary, that's something that you can suggest. And then additionally, as I had said, the court has, oh, Reedy, I'm sorry, I'm ready for the next slide. The court has the power and the authority to really address this. And there are a couple rules that really support the court addressing this. So first is Civil Rule 1, and it says that court rules shall be construed and administered to secure just, speedy, and inexpensive determination of every action. And restrictions on litigants, you know, they need to be consistent with constitutional right of access to the court. So that is a balance that the court has to strike. Civil Rule 11 can be a very effective tool to address this. Civil Rule 11, basically what Civil Rule 11 says is if an attorney or a pro se litigant, but if an attorney signs a pleading, a motion, a document, they are certifying that what they are presenting to the court is well-grounded in fact, warranted by existing law or good faith argument, not interposed for any improper purpose, such as to harass or cause unnecessary delay or cost, and that any denials of factual contentions are warranted on evidence or reasonably based on a lack of information or belief. So if an attorney is engaging in abusive, if a perpetrator or an abuser is engaging in abusive litigation and they're being assisted in this by their attorney with frivolous or meritless actions, then this is a potential tool that you can use. There are advantages to bringing a motion for sanctions under Civil Rule 11. It's not limited to just attorney fee awards. Courts can be creative in fashioning other sanctions that might be more effective, and you can certainly be creative in suggesting them. The court can bring it on its own motion, which certainly is helpful in cases where a survivor may be unrepresented. It punishes attorneys who enable litigation abuse, and it holds abusers accountable. There are some disadvantages to Civil Rule 11 as well. Courts may be unwilling to impose sanctions under CR 11, particularly on pro se litigants. And then the imposition of sanctions in and of itself could actually lead to more litigation. I will say, you know, this is a helpful tool, but I'm not certainly not suggesting that this is an easy burden to meet if you are trying to, all I can think of is allege, and I don't want to say allege. If you are trying to make the court see that abusive litigation is happening, this can be a tough burden to prove on your part. But if you can establish that the other party is doing this, then this is a really effective tool. There's statutory recognition of the court's authority as well. So there on the slide, RCW 228010, Section 3. Every court has inherent power to control the conduct of litigants who impede the orderly conduct of proceedings. And RCW 484170 allows a prevailing party to request fees where the action, counterclaim, cross-claim, third-party claim, or defense was frivolous and advanced without reasonable cause. So there are other avenues for you as well.
I think it's also helpful to know the statutes just because a lot of times when we're bringing those CR11 sanctions just on their own, you will see courts sort of roll their eyes because often the abusive litigator themselves may be trying to sanction you based on like their own frivolous claims. And so having this statutory authority that you can point to, I think can be very, very helpful. Also, just reminding the court that, our statutes also support the courts really making sure to curb abusive and inappropriate conduct by litigants. So some other remedies that can be used by the courts, some courts have required abusive litigants to post some sort of payment or fee ahead of time before proceeding with new litigation. Money is such a motivating factor that requiring some sort of upfront bond can hopefully curb abusive litigation. We've had a few cases where the court has then basically ordered the abusive litigant from filing anything further without express permission from the court. And we've taken that order and we've actually attached it to other cases that the litigant may have started in other jurisdictions, just to let the court, other courts know, other judges know that they do have the ability, they do have the authority to be able to take responsive steps against abusive litigation. Something that it doesn't always make sense. Of course, you may not want limits placed in your case on pages or how much information you can include, but if it, depending, it may make sense to ask the court to require limits to be set in your case about maybe the number of pages, the number of words in a brief, or having very strict deadlines on filing so that the abusive litigant doesn't continue to come back and make last minute filings that then the court doesn't have time to review, and then it almost by default requires another continuance. So really encouraging the court to think about these types of remedies and these types of limitations that could be put in place that still allow for due process, that still allow for both parties to be heard, but also ensure that the litigation continues to move forward and isn't bogged down in these abusive tactics. Do you want to talk about fees, Sarah?
Sure. So many states authorize awarding attorney's fees or costs to a prevailing party. Fees are awarded in dissolutions for enforcement and modification actions after the entry of judgment. But under that statute, the court has to consider the financial resources of both parties. So there are some limitations. There are other limitations to keep in mind as well. Seeking fees, that's limited use of that by unrepresented survivors because typically they're just not even aware of the option. There is such a thing as judgment-proof abusers and abusers who just can't, and then abusers who can afford to pay. So will the survivor ever even receive the fees or the survivor's attorney? And then fee awards, again, can provide a basis for more litigation or appeals. So that's something to keep in mind and to weigh in deciding whether to move forward with that. Basis for seeking fees, a party's intransigence, intransigence, just generally if one of the parties is just completely and unreasonably inflexible, unwilling to cooperate or concede in any way, and again to a level where it's unreasonable and it's causing unnecessary delay in the action. For filing frivolous contempt motions, for using or frustrating the dispute resolution process without good reason, for bringing modification actions, trying to modify an order in bad faith, and then for bringing frivolous civil cases. Those would all be basis for seeking fees as award.
And before Sarah talks about the next slide, I just also want to add, we're using fees here, but also when you're asking for some sort of remedy that might be monetary based, like thinking about when you use the term fees versus when you use the term monetary sanction or something like that, because the court can respond differently depending on how you sort of present it to the court. And so one thing we've done in the past, we haven't always been successful, but surprisingly on a few cases we have been successful is instead of asking for attorney's fees, we've asked for a monetary sanction that should be made payable to another community partner of ours, like Eastside Legal Assistance Program, KCBA, Legal Voice, that is doing similar work. And courts have actually seen that. We've had some judges who are very responsive to that because I think they see it as holding somebody accountable and the other party isn't getting like enriched or something like that. Not that any of our legal aid attorneys are super rich or anything like that, but just kind of thinking also about the language of when you're using the term sanction versus fees and what your basis for the request is. And then maybe does it make sense instead of the statutory authority for the fees, instead of that, if it makes more sense to kind of use the language of sanctions and monetary remedy or something like that. Sorry, Sarah. Next
No,
one.
that's okay. That's a really good point. Last year, our partners at Legal Voice and Northwest Justice Project worked really hard to pass legislation that called out abusive litigation. So we have RCW 2651-010 that defines, well, 2651 defines it and sets out a procedure for it. And then on the screen, we've got 2651-010, which defines it. So right now, it does only apply in a domestic violence context. So that limits what parties it applies to. And there has to have been a finding of domestic violence against the abusive litigator. So there are some somewhat narrow parameters under which this can be applied, but it is still very exciting. It's amazing work that was done, but it is in the family law context. And as Reedy, I think, pointed out earlier, we see these tactics and we see abusive litigation in other kind of cases as well.
And this is really exciting to actually have statute that actually uses the term abusive litigation, actually defines it. And then this legislative session, a lot of us, many of us tried to take it a step further with House Bill 1320 that has passed and will be, is basically taking all the different protection order statutes, making it one statute. So a pro se survivor, pro se litigant does not have to figure out which statute applies to them. And I wanted to specifically highlight the section 39 that expands on the work that was already done under 2651 to increase the sort of ability to respond to abusive litigation, at least in the protection order context and other protection orders, with the exception of the extreme risk protection order. But for stalking, for anti-harassment, we see this a lot in sexual assault protection order cases and stalking cases, the vulnerable adult protection order cases. Basically, also being able to now identify abusive litigation when that's happening within the protection order context, and restrict the respondent from continued frivolous filings against the petitioner, from preventing, earlier when Sarah talked about like engaging other systems, making false reports, restricting them from that, or restricting them from being able to like engage in harmful communication about the petitioner to other parties. So that's also really exciting to be able to build off of the work that was done last year on 2651 to bring it into protection order context. So now we can apply it to the not just DV cases, but also stalking, sexual assault cases, and other types of gender-based violence cases. Another piece of legislation that also passed that may sound exciting, but right now we're kind of concerned about how it may play out is HB 5009. So often, especially we see this in sexual assault cases where defamation lawsuits are used against survivors for calling their abuser out, for calling their rapist out. We've seen this happen in a lot of high profile cases like with Weinstein, with Cosby, and the defamation statutes are often weaponized against survivors who are seeking justice. And so a lot of states have these anti-SLAPP legislation, which is essentially an expedited way to sort of bypass complicated, drawn out litigation that are often defamation claims. And Washington had one on the books for a while. It got struck down by the Washington Supreme Court because of how it was worded and how it applied. It was seen as unconstitutional. And this year, new legislation was introduced and has passed that is essentially trying to create another anti-SLAPP. It has created another anti-SLAPP legislation. And I think the case that struck it down was Davis v. Cox. But this new legislation, so the main target of this new statute is defamation and claims of harm to reputation. But the way it's written, it's really complicated, and there are some consequences of bringing there are consequences of bringing a strong defamation claim. There are also consequences of engaging in the anti-SLAPP aspect of it. And then there are like exceptions that are really, really confusing. I just want to make sure that you all are aware of this legislation in case it does apply to you. But we have not seen the implementation of it yet. We have not seen how this is going to play out in courts. For us, one red flag is that you could engage in the summary judgment anti-SLAPP aspect of the statute, and if you don't succeed, then you can end up actually owing the other side financially, and that is very intimidating to survivors. So this is potentially a remedy. This is potentially a strategy against abusive litigation, but we just don't know enough about how the implementation of this statute is going to go. So tentatively hopeful is the way to maybe talk about this legislation. And then Sarah, do you want to talk case management strategies?
Yeah, so here are some things that you can do to address this. And kind of as Reedy mentioned before, there are, you have to think about whether this is going to work for your particular case and your particular situation, but these are options that you have. So one, try and keep all proceedings before the same judicial officer and try and consolidate all related cases so that they are before the same judge. And then expressly retain jurisdiction over a matter after the final orders are entered. And these are things that can be done, the first two can be done early on to sort of nip any, or try to nip any potential efforts by an abusive litigant early. So in talking about this, we kind of compared it to when we go into a protection order hearing and maybe you have a very aggressive respondents counsel. But if you very early on make objections to maybe improper questions that they're asking or procedural errors that they're making, because protection orders are special proceedings. If you do that early on and you do it consistently, then oftentimes you're going to see that those aggressive tactics slow down. So if there are things you can do in the beginning to sort of set the tone that you're not going to be bulldozed, I guess, that's a good thing to do. And then additionally, beware of sort of the tit for tat responses. It's really easy to kind of get to go down the rabbit hole. You don't want to lose focus of what your case is about, what your strategy and what your narrative is. And if you get caught up in what they're doing, you can lose that focus, and suddenly you are following and echoing the abuser's narrative and playing right into their strategy. So for example, they may try and focus on the survivor's mental health versus the abuser's conduct, or you know, a particular example would be the rape. They may want to try and focus on a survivor's past relationships instead of trying to shift the focus from their conduct, which may be stalking. So that is an incredibly common tactic by respondents, particularly abusive litigants, and you want to balance appropriately addressing it and rebutting it with not allowing it to become the focus of the case. And then obviously you want to do what you can to minimize the impact that all of this is having on your client, the burden that it creates on a survivor. So you want to try and recognize abusive litigation early in order to curb.
Hello? Hey, sorry, I forgot to call you back.
Oh, it looks like someone's not muted. If everyone could just check their. Thanks. So again, you want to recognize that it's happening early so that you can address it and hopefully curb any future effort or impact that it might have. So ways you can do that. Don't just routinely agree to continuances. I know that they are very common in litigation and they don't seem like a big deal, but in fact, again, repeated continuances is an extremely effective and common tactic in abusive litigation. You can ask for filing schedules and court order deadlines, even in cases where that's not necessarily the norm. We've seen that, we've requested that and seen that happen in protection order cases. You again recognize that switching attorneys is a common delay tactic. You know, oftentimes we will see courts recognize that there have been too many continuances, and they will say to the respondent, abuser, this is it, this is your last continuance. And then suddenly they show up with a new attorney, and the court is faced with the really kind of hard job of balancing whether or not to stick to what they said or to actually give this attorney time to prepare. So making sure that you are recognizing what's actually happening and bringing it to the attention of the court. And then Reedy talked about the potential for having the court put a limit on pages or word count for pleadings and other things that are filed. And again, you just have to decide if that's something that you want in your case. There's a lot of opportunity to be creative, to be flexible. So you just have to, again, look at your case and see what might work best for you. And then on the slide, we talk about some other things that you can do as well. Yeah, and I think at this point, we were kind of hoping to engage with all of you and see if any of you, most of you have said that this is something that you've encountered in your cases and that your clients have experienced. So if you want to put in the chat, maybe some, either some specific experiences you've had or ways you've addressed it, or tactics and strategies that you've used, that would be great.
And we are recording this. You are more than welcome to unmute yourself. Just know that if you turn your video on, you'll show up on the recording as well. And I had seen a question about like the RPCs, like again, we didn't actually go into all the RPCs because a lot of abusive litigants are also pro se, and sometimes it's clear like the attorney is on board with it based on the attorney, but if you're also dealing with a pro se litigant who's like switching a lot of attorneys, maybe focusing on the attorney doesn't really help in responding to abusive litigation, but there are definitely several RPCs that come to mind. There's like 3.1, which is about like, I think, like meritorious, is that the one? Like if it's a meritorious claim, I think 3.3 is like related to being candid to the tribunal. I think sometimes with abusive litigants, they if they have identified a like-minded attorney, it's just shocking just how much they're okay with lying in court. So 3.3 is another basis for a bar grievance. 3.4, which is about fairness to the opposing party. Maybe, you know, bringing in thousands and thousands and thousands of letters into court the day of. Like, I don't know how fair that is. Under, I think 4.2 is like communication with represented parties, and 4.3 is communication with unrepresented parties. We have seen with abusive litigation, we've seen this in criminal cases, for example, where the victim is very clearly represented, but then defense's investigator is still contacting the victim directly. And that would be a violation under 4.2 or 4.3. And then always 8.3, like I think that's the sort of general catch-all of around as an attorney having reporting misconduct under 8.3. So there are definitely a lot of RPC options for bar grievances. We just didn't want to focus only on attorney conduct. And if we're going to do that, we want to make sure you get your ethics credit. So we can maybe have a separate CLE on that as well. But are folks sharing in the chat?
I'm not seeing anything.
I know there's a lot of expertise out here just based on seeing the participant notes and so the names. And so are there other sort of strategies, motions, other tactics that you have engaged in to be able to respond to abusive litigation? Another way to think about this is, have you seen courts do anything that's creative that you were like, wow, that's great. I hope more judges did this.
Oh, so looks like we do have, so we have someone, we get a lot of situations in DVPOs in which we need to realign the parties. And another person said they had the assigned judge appoint a special master.
Thank you for that reminder. I hope I'm saying it right, Marieke. Thank you for that reminder that the DVPO statutes very specifically allows parties to be realigned, where if the court finds out the respondent in the case was actually the victim and it just happened to be the abuser got to court first and filed the petition, the court has inherent authority under that statute to switch the parties. That's what the realigning means, so that the victim who was identified as the respondent now becomes the petitioner, the protected party. And HB 1320 actually has allowed that to be expanded to some of the other protection orders as well, because that is a really great response to abusive litigation in a protection order context.
Someone said that appear without their client present when it isn't necessary. So that's certainly a way to alleviate the burden on the client. In one family law matter, several DVPOs filed. Family law judge retained jurisdiction, and before any motions could be filed by respondent, had to see his mental health provider and provide proof plan for motion was discussed. That's creative.
We have like even if a court hasn't provided like ongoing sort of order around like restrictions around filings, if we've been able to get like any sort of sanction or any sort of finding at all against the respondent related to abusive behavior or the need to like be sanctioned related to that specific case, we've actually attached it to future filings in other jurisdictions. So that's just something to also keep in mind. So we are wrapping it up. I'm going to just give it a few more seconds. Does anybody want to unmute? Maybe typing is exhausting because we spend so much time on our laptops. And does anybody want to unmute and share an example? Okay. Well, if not, we'll still be on here for a few more minutes, but if not, please, please, please also fill out the survey, the feedback survey. I think Natasha posted it earlier. And then that way we can also ensure that you get CLE credit, and it also helps us improve these trainings. And the next training is going to be, it's the third Thursday of the month. So it's July 15th. And the next CLE, we're going to be focusing on stalking protection orders. With that, thank you so much. Thank you for joining us. Sarah.
Oh, we had there. Hold on, we had one more. Says congratulations to Reedy on the Golden Tennis Shoe Award.
Thank you so much. Thank you so much for that. But Sarah and I will stay on a few more minutes for any folks who may want to talk through. And of course, feel free to contact us if you want to talk through a case that you have, just to strategize, or because you're not sure if it's abusive litigation, because sometimes these cases do get very heated. But we're always happy to talk through any sexual assault, DV cases, stalking cases that you might have, where it's helpful to have another attorney to discuss it with. Thank you all.
Thanks, everybody.